welcome to Newsclick. On 31st July, the central government ordered internet service providers in India to block around 857 websites for supposedly carrying pornography. The government's decision to act as a moral police has of course led to a lot of debate on the issue of freedom of speech, particularly in the context of the internet. The ISP industry and large parts of civil society have come out against the ban, with intermediaries pointing in particular to how they are being put in an adjudicatory position, something that they are not equipped to do. To discuss these issues, we're joined by Prarbir Purkayastha, Chairperson of the Society for Knowledge Commons and editor of Newsclick. Hi Prarbir, thanks for joining us today. Given that the Supreme Court has not passed any specific orders directing the government to block pornography websites, and further that watching pornography in India in private is not per se illegal, why do you think that the government has taken this action? So do you think that this is part of a larger culture of moral policing by the right wing, or do you think that this is something that is legitimately within the government's purview to take action on?
Well, I think the trigger was that the Supreme Court talked about child pornography and that something needs to be done, and child pornography is obviously a sensitive issue. But the rest of it, a mass blocking of pornographic sites, clearly is a knee-jerk reaction, and it is governed by essentially moral policing, as you were saying, or what others have said. So it's very clearly moral policing, and it is a problem of various kinds, because what constitutes pornography itself has been a long debate
for the ages.
Ages, and if this what is being talked about is pornographic sites and so on, a lot of them are actually not. The bulk of them probably are. A lot of them are probably not. So this is really getting down into this level, trying to identify sites, asking ISPs to do various things, I think is also a long-term problem, because it doesn't only pertain now to pornography, which is always where it starts first, but it could also go on to saying now extremism we will ban, other things we will ban. So I think the principle of bans itself is a problem, and it always starts with pornography. So that's where it really starts, but it quite often spills over to other things, and that's the threat we have.
Now, there are two basic issues at play here. First is the issue of whether pornography itself is harmful to society or not, whether this should be taken care of in one way or the other, whether it's banned or not. And second is the issue of this specific order, which has resulted in the blocking of 857 sites, and whether this is in consonance with the extant legal framework. What is your stance on the issue? I mean, how would you look at dealing with the issue of pornography, particularly given that child pornography, as you said, is generally consensus that you should ban it?
I think child pornography is always the exception which almost all countries have accepted should be banned. And the question is, even watching child pornography, downloading child pornography in many jurisdictions is banned. So that, I think, is a relatively much clearer issue, and which there is a broad consensus, except perhaps the United States, where it's still what can or cannot be done is still an iffy matter. UK, it's even harder. That in fact UK's laws are, and the practices are even much worse than any of the other, for instance, countries in Europe, or most countries in Europe. So I think the issue of child pornography is a settled one. On the issue of pornography, I think that it's very clear that the general tendency is to go to a much more relaxed environment on the child pornography, watching pornography. And it also is something a part of Indian culture, because after all, if you really ban what is called quote-unquote pornography, would you ban Khajuraho, would you ban Konarak, would you ban Kama Sutra, and so on. So I think that we need to be really much more sensible about these issues. And it's also interesting for me that while we are quite happy to talk about banning pornography, but we don't talk about banning, for instance, extreme violence that we see on the movies. That is taken as norm. So I do think that these things are much more problematic in terms of dealing with bans, and society has a right to finally decide as a part of its norms what it considers should be watched or should not be watched, and let the people decide much more individually than a social bans.
Moving on to the second issue then, the websites that have been banned this time, it appears, have been blocked not under Section 69A, which is the provision that actually allows the government to go and block content from being viewed by the public, but under Section 79, which is the provision that is supposed to ensure intermediaries are not held liable for content that they just help users access. So do you believe that the government's actions in issuing this order under Section 79 of the IT Act are valid?
I think it's a very, very important issue which has not really received the amount of attention it deserves. issue from the beginning has been with the section 79 that it can put the onus of censorship on the intermediaries, which is what by law should not be done, because the right of censorship and review by the courts is fundamental to section 19 of the Indian Constitution, which is freedom of speech and reasonable restriction thereof. It's not for commercial enterprises to look at these issues in that framework. So putting anything to be blocked under 79 is really allowing state powers to be given to private entities to be exercised, and under the threat of what is in the 79 is really withdrawal of safe harbor. The intermediary protection was that if you carry things which you have not generated yourself, you have safe harbor if you follow certain provisions. And from the beginning, Knowledge Commons, and you were a part of that, has already talked about how this itself is so vaguely worded that it can lead to ultimately asking the intermediaries to exercise censorship powers. And that's what seems to have been done by this order, because first they asked them to block, which was relatively threat of withdrawal of safe harbor. Now what they've asked is, you decide whether this child pornography on these 857 sites, and you decide what is to be blocked or not. This is straightforward giving up government censorship powers to intermediaries under the threat of safe harbor. I think that's unacceptable.
Now, as you just mentioned, Section 79 of the Act provides that an intermediary should take action to take down content if it has knowledge that it's furthering an illegal activity. But the Supreme Court in the recent Shreya Singhal judgment read down this provision to specifically say that an intermediary only needs to act if it receives knowledge of an illegal activity based either on a court order or a government notification. This appears to be the sort of loophole that the government is taking advantage of in this case, because it's purportedly given intermediaries notice, i.e. a notification, that there is illegal content. Thereby they've put the onus, as you rightly say, on the ISPs to take adjudicatory action. So do you think that the government is actually acting in accordance with the Supreme Court's dicta, or is it violating the Supreme Court's order?
Supreme Court also said specifically what are the conditions under which the government should issue this or this blocking orders, and it said certain threat of integrity of the country, incitement to violence, etc., which are very much a part of 19(2) reasonable restrictions. Now this actually court did not mention pornography, obscenity, which is also could be construed as a reasonable restriction. Court didn't actually mention it. So this, I think, if we look at the Supreme Court order, this is going beyond what the Supreme Court had ordered. So I don't think that loophole exists in the order the way you were saying, though essentially it was that government allowed that 69A blocking provisions to be retained. It didn't also talk about 79. So I think these two things have to be seen together, that essentially 69A, the Supreme Court accepted that certain things can be blocked if it conforms to 19(2) reasonable restrictions, and it also said only certain items of 19(2) reasonable restrictions. It didn't say everything in that, but it could be argued that it is the whole 19(2) reasonable restrictions. So obscenity also comes into that, but it did not suggest that the safe harbor be linked with this. So I think this extension of this argument to saying withdrawal of safe harbor and putting the adjudicatory responsibility on the intermediary, I think is going far beyond what the Supreme Court had ordered.
Similar to the previous instance of blocking, which we saw a few months, about 5 or 6 months ago, involving GitHub and so on, the government has once again ordered all ISPs to keep the blocking order confidential. The Supreme Court in the Shreya Singhal case again has specifically noted the various safeguards present in the law in the case of blocking content under 69A. So for instance, you're supposed to provide a hearing to the other party, there are multiple layers of review and so on. So these conditions, one would think, have not been followed in this particular case, given that the government has gone under 79. So why do you think there's this veil of secrecy over the government's actions, particularly in this day and age when it's practically impossible to keep this sort of...
It's a very interesting issue that you're raising. The government's instincts always seems to be keep everything secret unless it's forced to release it. Now that's the way the government seems to operate, which it has operated in this case. And obviously, as you say, these things, given the fact that you're giving notices to so many ISPs, is impossible to really keep a secret. But the principle of it, really the Supreme Court should have laid down, that of making the order public rather than saying redressal by the affected parties, because then it's only those who are running the websites who get that redressal, but nobody else does. So I think the Supreme Court erred in that order by not saying any such order should be made public, and giving therefore the government the leeway to cover this up and make it much more difficult to get the information, though as we all know, this information really leaks out pretty soon, particularly in India.
Now, finally, in today's day and age, I think it's important to consider the practicality of any of these bans. You've already mentioned that in theory we should not undertake bans of this nature, but is it practical to actually enforce any kind of ban of this sort? And what do other countries do about these sort of incidents?
You know, there are of course different levels of approach that different countries are taking. First, is it technically to ban? I think it's almost impossible to impose a ban of this order because from the user, you have now tools like proxy servers, you can go through the onion router, the Tor route, by which all this would anyway get bypassed. And any young person at the age of 13, which is supposed to be the at-risk 12, 13, they actually seem to know more about it than their parents do. So it's almost impossible to prevent children from doing if they want to. So you have to really teach them what is good and what is bad instead of trying to block. So that is one. The second part of it, and this is an even more difficult exercise, that the porn site can continuously change their IPs, their names and so on. And it's almost, again, if you start to put things underground, it's almost, apart from criminalizing, it's almost impossible to really stop it. So and because criminalizing takes place abroad and it doesn't take place in your own country, there's not much the police in any country can do. So either you deal with it as an international issue and have an international understanding on it which everybody agrees to, which is rather difficult.
Yeah, on an issue like this.
On an issue like this, because cultural mores are so different from US to Turkey to China to England. And forget all this, even from US to UK, there's huge difference in the approach that seems to have been taken. So I think that international accord is going to be difficult, and I don't see that technologically it's possible really to hold the wall as the governments want to do indefinitely.
Well, that's all the time we have today. Do join us again for another episode on Newsclick.